So I've got a bit of an update, really. So I had a, I did a drawing or a diagram, right, for the timeline. So this is a timeline, right, and I've started it at around 1627 up till now, right? And I had a more basic one, but this is now updated and improved. Could probably improve it further. It gets a little complicated around there, right? But I've like kind of unravelled a lot of the legislation. Well, a lot of the courts format and procedures, right? So the the tumultuous petitioning act 1661 is there, and then the 1688 Bill of Rights is there. Okay, so they've got these hundreds courts, which they had the hundreds courts before the magistrates courts, right? And they were like the divisional county court. It was like the divisional courts all around the country, and they had justices of the peace, right? Now, the justices of the peace didn't always get paid. Um, the thing is, so they did hold sessions, but sometimes they held sessions in people's houses and so forth, right? Now, the thing is, you could approach a justice of the peace, actually approach them when they were out and about. There were certain things for like poor people and getting relief from the church and so forth. If a priest or someone, you could actually get them to write an order out there and then, right? So you could actually get them to write orders out for certain things themselves. Except obviously if you've got a trial, then you had a jury. They did have the jury for the hundreds courts, right? But they removed it. They started messing around with the juries and removing them. Sort of like it's looking like around the mid 1800s. You've got this Summary Jurisdiction Act, and you've got these Common Law Procedure Acts and all these other acts, right? Now, as well as these hundreds, right, which ended up being the magistrates' court, the district judges in the magistrates' court, a magistrate court can actually hear civil matters, but the thing is, right, later on, the assizes and the quarter sessions started taking on more criminal cases, right? So they didn't need to be dealt with as much in the other courts. Now, the thing is that you've got these quarter sessions, right? These quarter sessions took place 4 times a year, right? And you had quite prominent judges in them. Now, as well as the quarter sessions, you had the assizes. Now, I thought the assizes were sort of permanent, but those were twice a year. And you had the circuits going round twice a year, right? I think once you get over once you get over up to 1900, right, you start having them around 4 times a year. But those assizes were only like the quarter sessions, right? So you'll be a lot better to approach your local hundreds divisional county if you want certain things putting through. Now, the right to petition is actually based on a lot older law, like Magna Carta and the Petition of Right. The Petition of Right is 1627, okay? So they've always had the right to petition and be doing it. And the basis behind the right to petition itself is on the fact that it is bringing a legitimate case to the king or to parliament, right? And when you're getting the signatures on it, that is the consent of the peers, your peers, like in Magna Carta. So if you are officially bringing some kind of case, complaint, grievance. It can be an accusation, like a criminal charge or claim or civil claim. It's officially a proper case, and you're getting the witnesses' signatures on it and consent to do it. So it's like assisting offenders, really, when you're helping the police or pursuing criminals. The CPS and police as assisting offenders, where they can take on witnesses with immunity, is only based on the assisting offenders in the 1967 Criminal Law Act, which is that if you are pursuing or in pursuit of criminals, any person, or in pursuit of wrongdoing or crime. So it's based on assisting offenders, right? Which is, you are actually the claimant. It's based on the fact that you're the claimant with witnesses against something else, right? That is the actual basis of it. Now, in 1661, they brought in a law that you can't get more than 20 people subscribed to a petition unless you get consent from the courts, right? Or try present it to the king as well, like 10 people and so forth. Those were offences for actually large petitions without consent. But remember, if it is a legitimate petition, lawfully done, you're meant to have privilege anyway, immunity, indemnity, right? It's only the fact that people were doing it and they were getting extremely large numbers of people, mobs and so forth, because you can have remonstrations. A public remonstration is almost like what Extinction Rebellion and Just Stop Oil are doing now, right? Now, the thing is, right, that so the case of William Penn and William Mead, which is 1670, that's a prosecution in the Assizes, Criminal Court, the Old Bailey, against them for the accusation was that they were actually doing a very large petition in public, right, and causing trouble without consent. That was a criminal charge against them. But the jury made out that they weren't doing a petition anyway in the first place. They were just talking in the street, and it wasn't anything to do with a political action. So they weren't even claiming political immunity because the jury said that they weren't. Well, William, Mead, and Penn are talking about Magna Carta, right? But the thing is that you have got Magna Carta protection and rights, but the Tumultuous Act made it so that you had to get consent to do it on a larger scale. Okay? That's the main thing. So, because all the things that happened to John Bastwick and Henry Burton, they were prosecuting against them. The king was, because they were trying to get certain laws made and changed that the king didn't like. It wasn't really anything to do with that they were like, it wasn't things they were doing against their fellow citizens or anything like that, like a criminal charge. It was actually the king who didn't like what they were doing, even to pursue getting laws made and changed. So these quarter sessions and assizes, you've got like civil actions and criminal actions. Now, the thing is, you had the old courts of civil requests, right? So the Tumultuous Act, to get consent for doing a large petition, right, it's looking like it's going to have been through these courts of civil requests, because you're requesting for consent. And I think it could have been in the assizes, which were twice a year, or in the quarter sessions, which were 4 times a year, or you could go into the divisional court. But you had to get permission from 3 justices or the grand jury. Now, remember that the hundreds courts did have juries up till here, right? Or you could get 3 justices. Now, the thing is that you might have been able to approach those justices out of court when they were walking around and maybe get their signature of consent, but you would have to get 3 of them to consent to it, or the larger part of a grand jury. Now, if you had under 20 people on a petition case to Parliament, you didn't need to go through the courts of civil request, right? You only had to get consent to proceed if you're getting large numbers of people. Obviously, if you had a grand jury, then that would be, consent from an equal or substantial number of large people to consent it, right? Now, you've also got the Court of King's Bench as well, right? The High Courts. Now, the thing is that these courts of civil request, therefore, the records of them are important. Now, I'm just a little bit confused whether the courts of civil requests was something you could do in the Court of Sessions or Assizes or hundreds as well as them hearing criminal cases. But the hundreds aren't a court of record, a proper court of record, right? The Assizes are a court of record and the High Courts. Now, the courts of civil requests, it's saying that they began in 1483, but they didn't start taking records till 1485, and then they're saying that there aren't any records after 1642. So if it was a court of records from 1485 to 1642, then why did they suddenly stop taking records? I've got all these question marks here. Now, after 1642, you got another 20 odd years until the Tumultuous Petitioning Act comes into force. That's when you would actually start using the courts of civil requests to get consent for the Tumultuous Act. And then all through the 1660s and 1670s, like with the case of William Penn, up to 1688, right? So you would get all the civil requests of consent for the Tumultuous Petitioning Act requests. But then after 1688, apparently they didn't repeal the Tumultuous Petitioning Act, but 1688 Bill of Rights, you get all prosecutions for doing so are illegal. So you get your Magna Carta protection confirmed, as long as you comply with the Tumultuous Act. Now, these records of the courts of civil requests in this period missing here are of extreme interest to us, because there would be great details of dialogue in the proceedings and on the record of them talking about the Tumultuous Act and Magna Carta and the Petition of Right and the 1688 Bill of Rights, and how these people regarded the rights and the immunity and how the courts were talking about it and discussing it in detail. That's why the case of William Penn and Mead that is on the plaque at the Old Bailey, we've got the full details of that, but it wasn't a court of civil request to get consent. It was a prosecution for not getting consent, right? Which came through the criminal courts in London, right? Now, this is the interesting part. In 1846, the courts of civil requests they establish the county courts properly. Over 500 county courts around England. And the thing is, they do a little bit of switching around here, right? In 1846 and establish the county courts. Now, the Assizes judges, right? The Assizes judges start dealing with civil request matters, but in the county court. But in the regional county courts, you have an office of registry for the High Court. The high courts in London, central courts, have got registries in all the county courts around England, and the assizes judges were sitting in there, right? Now, they had a jury and a grand jury. So, and it says in 1846, the county court shall be a court of record. But what we want to know is, where are all the records leading up to there? Now, it's funny that Parliament burned in 1834 under Sir Robert Peel and King William, and all of the House of Commons petitions were destroyed, 90% of them, right? Funny that 1846 is not far off 1834. What happened to all of the courts of civil request records? Where are they? If it was a court of record, why would it suddenly stop being a court of record in 1642? That seems very odd to me. I think that these courts of civil request records would have been absolutely priceless in evidence of 1688 Bill of Rights evidence and tumultuous proceeding evidence. They established the county court as a court of record in 1846, right? So this is the question. What happens to the assizes? Well, the thing is, right, the quarter sessions continue up till 1971, and then the quarter sessions stop, right? The assizes being called assizes stop in 1971, and we get the Crown Court. But the Crown Court is mainly for criminal matters appealed by the Magistrates Court, right? Or if it's very serious, to the Crown Court anyway. The assizes judges civil cases in County Court, High Court Division, right? So the civil side, of the assizes, and I would have thought quarter sessions, were put into the county courts for county court matters, and they've got a connection to the High Court Division with assizes judges, not Crown Court, right? So, and then we've also got making changes to the juries, 1850s, 1876. The thing is that in 1933, right, they stopped having grand juries, civil juries, right, around 1933. So any civil matters in the county court could have had a jury up till then, and even like your consent. Now, the Tumultuous Petitioning Act wasn't repealed officially until 1986. The Crown Prosecution Service was created in 1985, right? So the law still was. They made an amendment in 1967 to the Tumultuous Act, changed from the court to quarter sessions, but it was already quarter sessions. There's something going on with the quarter sessions and court, between the quarter sessions and the county court assizes. The changes in the legislation to the Tumultuous Act, it already said quarter sessions. It didn't need to be changed to the court. So I think there's a error in the legislation. But And the reason they say they appeal it in 1986 is only because of presenting petitions to the king, not actually for going about getting consent through the courts to even do them over 20 people. What I want evidence of these civil requests for consent on petitions that have over 20 signatures using the Tumultuous Petitioning Act, right? And if we haven't got these Old Courts of Civil Request records prior to 1846, we've got a lot of the petitions which Dr. Brodie Waddell has transcribed, right? But they don't tell you anything about the proceedings, right? I think that these have gone missing along with all the House of Commons petitions. But anyway, so from 1846, the Quarter Sessions and Assizes civil side requests should have evidence of people wanting consent for petitions under the Tumultuous Act, right? And there should have been grand juries at least up till 1933, right? And then all the way up till 1971. After 1971, it won't have been in the Crown. I don't think they'll ever have been in the Crown Court as we know it, because that's criminal. So we're looking at county courts and high court records all the way up to 1986. So from 1846 to 1986, in the civil courts, Quarter Sessions, Assizes, and High Court, right? Someone knows something about it. I want records of the dialogue in the proceedings, what is discussed and talked about. We're not going to get it before 1846 because they've gone poof. I don't think that they just didn't record them, unless someone's got evidence of stated that we are stopping recording them, unless it's forged. Why would they start recording them and suddenly stop being a court of record? And that was well before 1661. We're not going to get records for the hundreds courts because they're not a court of record. There might be listings, but not evidence of things that were said or done in proceedings. And even now, today, magistrates' courts, I've been to magistrates' courts, they're not very honest, they are terrible, very corrupt, very much like in the case of Edward Penn William Penn and William Mead, just like those kind of dialogue proceedings, just absolutely atrocious to say that it's a court of the king, a just jurisdiction of England, justice. It makes criminals look like saints, put it that way. But I think that some of these petitions, if there were over 20 signatures, I'm starting to think that I wonder if some of them have got the signatures of the judges on the petitions, if they approached them and got them consented to. That's something that no one's actually mentioned yet. Maybe Dr. Brodie Waddell could say that, but how would you know who their names were on there? I haven't heard him mention it. I thought he might have come across it. But that's one possibility for those ones. But as for the proceedings, I don't think there's going to be any evidence of proceedings, right? There's quite a few other acts that I've listed coming into place. Quite a few acts of law that are relevant. So that's where I am with it now. So I need to find someone to do some research. I really think that we could be looking at the 1920s up till 1986, therefore in the county court and civil courts, but for consent for petitions. There's got to be some evidence of it. Now remember, even if you had less than 20 signatures, you didn't need consent. And also remember that prior to like the year 2000, around the time Gordon Brown was in government, they didn't have it online on the internet. So it wasn't all this kind of like dumbing it down on the internet. People were actually doing it properly in writing, officially, to Parliament and to the House of Lords. I don't know how many people still do that now, but I don't know how they've managed to get away with the online petition site, because the standing orders to abbreviate petitions and summarise them, but only when they're read out, not when you submit them with evidence, because through the Quarter Sessions Act and the Assizes and Quarter Sessions Act, I've actually read it confirmed you've got a legal right to give evidence which cannot be rejected, and a legal right to submit the petitions in casework, and the standard of which they're fit to be received is only on, like, the handwriting quality and eligibility. And it said there was no set form. There didn't have to be a prescribed or set form for them, right? Which and the Petitions Committee haven't come out with any legislation to me yet for anything, any of their standards or claims. It's all tosh. There's only the Tumultuous Act, some standing orders, and the 1688 Bill of Rights. Their standards are tosh. Actually, if there are any mistakes or errors, they're allowed to correct and amend them, but not change the writ of the petition or make you change it, because changing the writ of the petition is actually getting someone to change their statement, or that they're trying to manipulate the evidence that's been laid and given, and even censor it. You've actually got a right to lay the evidence as well. So, I need to do some more research, but I'm quite under 20 signatures, it being a legitimate case laid to government. From Magna Carta, with your 20 signatures, you're meant to have consent of peers, So, but you don't even need any signatures. I mean, if you've got strong evidence that you're submitting, that's where I am with it now anyway. So, I think Parliament probably know a lot more than they're letting on. And we know that a lot of these judges are quite corrupt and they don't want to grant people their rights. So the police as well, from the William Mead case, from my own experience, So I really don't know what to say about it at the moment, other than, corrupt and illegal practices prevention, particularly when your petition might be acting to prevent corrupt and illegal practices. And you're definitely entitled to indemnity then, and you've got excuses. Like the police having their entire job every day of the week for kicking people's doors down and damaging things. Excuses. And you've got more than a legal excuse than they have. If it's corrupt and legal practices prevention, it's not petty crime. So that's where I am with it now anyway.